Good afternoon. We are going to be beginning chapter 4, which is on divorce, separation, and annulment. And this will be probably a couple of lectures because there's a lot in this chapter. So there are several ways that you can terminate a marriage: divorce, separation, annulment, dissolution. Okay? One of my pet peeves is people call it disillusionment. It's not. That's what causes you to terminate your marriage. It's a disillusion. So when we're talking about ways that you can terminate a marriage, we're going to start with dissolution because it is the most amicable way to terminate a dissolution. Okay? A dissolution is where you go to the court with your spouse and you tell the court, we agree on everything. We agree that we are going to dissolve our marriage. We agree on how our assets are going to be divided. Our liabilities are going to be divided. And we agree on how we are going to raise our minor children. We agree on everything. And when you agree on everything and you come to the court together, what you do is you petition the court. A divorce, on the other hand, is an adversarial action where one spouse is the adversary of the other spouse. This is where you jointly are petitioning the court. And so it's a very different kind of process. With a dissolution, you prepare an entire packet of pleadings, file them all at the same time with the clerk of courts, and then the clerk of courts will give you a hearing date. That hearing date will be within 90 days of the date that you are presenting your petition to the clerk of courts. So from beginning to end, if you and your spouse decide that you are going to terminate your marriage through a dissolution, the longest it will take is 90 days or roughly 3 months. And typically you can get it done even more quickly than that. That is the longest period of time that it will take. Okay? So what is dissolution? What's in this packet? How do we petition the court jointly? Well, it starts with, before you even get to the court, you and your spouse sitting down and saying, okay, we want to amicably divide our liabilities and our assets. What does that mean? Okay, when we talk about the estate of our marriage, a marital estate, in every state except for those few community property states, what we do is we say, okay, when I came into the marriage, I had this, you had this. By law, we're allowed to keep that. Do you care? Maybe you don't care. Maybe you came into the marriage with a car, and then you traded that car in, and you got another car, and you're going to keep that car. Okay, so nobody cares. Everybody's fine. Okay? Everybody decides what it is they're going to keep. And you start with, what did we have premarital? Are we going to be able to keep those things? And then you divide up your other stuff. So I'll take the bedroom set, you take the living room set. I take the kitchen table, you take the dining room table. I take this car, you take this car. Okay? If there's a house, we're either going to sell it or you keep the house and you buy out my interest in the house. You divide up everything that you own. Now, when it comes to your liabilities, sometimes those intertwine with your assets, right? Maybe I'll keep the car I drive, you keep the car you drive, but there's money owed on my car. Okay, well, you're going to have to pay that debt off because you're getting the benefit of driving that car. I'm going to move this a little bit so that you don't get so much glare. Sorry. There you go. So, So you have to decide, if there's a car payment, whoever's keeping that car generally will make that car payment. If there is a mortgage payment, okay, we will both pay the mortgage payment until the house sells. Or I'm going to stay in the house, so I'll have the house transferred into my name, and the mortgage payment will be for me to take care of. Whatever it is. If I've got a Visa card and you've got a Discover card, you keep what you pay that bill, I'll keep that bill. But those liabilities have to be accounted for when you are deciding to have a dissolution. So if you've decided to do all of that, let's assume you don't have children for the dissolution, then you can put that all down in what's called a separation agreement. And the separation agreement is where you tell the court, look, court, we know that you have the right to order who pays this debt, who keeps this asset, and divide up everything that we own, right? But we've come to an agreement. Remember, agreement in the law always means contract. So we've come to an agreement, and we would like you, judge, to sign off on this agreement. We agree contractually that we're going to follow what's in this separation agreement. And so all you really have to do, judge, is sign off. Okay? Well, a separation agreement is the big part of when you go to the court and say we want a dissolution, because what you're doing is you're presenting the court with an agreement between you and your spouse that says how everything is going to be divided. You've already done the judge's job. If you don't have that separation agreement, well, the court has no way of knowing that you actually have come to an agreement. You can say, yes, we have an agreement, and then at the 11th hour, everything falls apart. Okay? And so it's really important that before you go to the court with your packet of everything that you need to have completed, that the separation agreement is completed within that packet. Now, as part of what we're going to do in this module, there will be a link for you to look at a separation agreement so that you can understand what is in a separation agreement. It's one thing for me to tell you, yeah, you got to have a nice little agreement. Well, there are specific parts that have to go in that separation agreement. You have to put into the separation agreement, if you have any real property, how is that going to be divided? If you have any personal property, how is that going to be divided? Remember, real property is land and anything that's permanently attached to the land, right? Personal property, anything that's not real property. So personal property can be your car, your camper, if you have a camper, your four-wheelers, your boats, your, big stuff like that. And can also be your furniture, your clothing, jewelry, any collections you have. And so within the separation agreement, there's a section for real property. There's a section for personal property. There's a section in a separation agreement about things like collections, guns, furniture, art, whatever kind of collections you have in there. There's a section about your bank accounts. How do you split up the money that's in your joint bank account? And then checking account, savings account. Investments, if you have certificates of deposit. Whatever you have, financially has to be split up. And what about your retirements? How are we going to split up those retirements? That is in your separation agreement. If you have children, and they're minor children, how are we going to handle raising these children? How are we financially going to do that? And how are we going to decide what school they go to, what doctors they go to, who's going to be in charge of those kinds of things? All of that is put into a separation agreement. Okay? Whether or not there is going to be spousal support. which we're going to get into in the next chapter. Whether or not there's going to be spousal support goes into a separation agreement. Miscellaneous things like, believe it or not, who's going to get your animals? Now, for some people, you'll like, their dog? Who's going to fight about a dog? First of all, they fight about dogs. I've actually done separation agreements where we've had visitation for dogs, believe it or not. Usually it subsides, but, you know, for a lot of couples who don't have children especially, those dogs are part of the family, right? More importantly, what if there is a business, a family business that needs to be split up, or livestock, right? It might not be a family dog, it might be 150 head of cattle. They have to be split, okay? So the separation agreement is a lot of hard work before you get to go to the court and present your petition. And it has to be done before you go, okay? And it's a contract. So both spouses have to sign off on that contract. Wow, that's a lot, isn't it? Well, most dissolutions are best accomplished when couples haven't been married for a long time. Because as I've just gone over, the more stuff you have to split, the more the likelihood is you're going to have a fight, right? If you've been married for, say, 3 to 5 years or less, and you haven't amassed a lot of marital property, boy, it's way easier to split things up, isn't it? Right? If I haven't had time to go out and buy the camper, and buy the four-wheelers, and buy the vacation home, and do the investments, and, the shorter the period of time, the more likelihood it is we're going to have a dissolution. It's also more likely that you're going to have a dissolution if you don't have children. Because, boy, you can split up the furniture really easily. Splitting up the children's not so easy. Not so easy. In fact, most divorces, most adversarial proceedings are about children, not so much the stuff. There's a couple of reasons for that. The first is, obviously, they're your children. You do not want someone else raising your children. You want to be a part of your children's lives. You want to maximize it. That's the first reason. The second reason is you hate your spouse, and you don't want your spouse turning those children against you. And the third reason that we fight about children is we use them as a proxy for our feelings about our spouse that we are terminating the marriage with. So the children, it's never really a good situation, and there's lots of reasons to fight about them. So typically you won't have a dissolution if there are children involved. Maybe if the children are older, and that could be another situation where, you know, people have been married for a long time and they're just tired and can't fight anymore. They've done their fighting for the first 19 years of their marriage, so in their 20th year, they're like, forget it, let's just get this over with. The kids are grown, we don't have to worry about things. So when children are much older and where the adults have reached some kind of a détente, sometimes you'll have a dissolution always. But dissolution is a very specific kind of process, and the facts have to be just right for a dissolution to really work. Okay? So, we haven't gotten to the court yet. We're putting together all of the necessary documents we need for the court. The separation agreement's the first thing. If you can't agree on how you're going to separate everything out, then you're going to end up in a divorce. So that's the first thing you got to get off the table. Now, lots of people who go through dissolutions say, we don't want to waste a lot of money on lawyers. Okay, fair enough. So maybe one party will get a lawyer and draft everything and put everything in order for the dissolution to go through. And the spouse who doesn't have the lawyer looks over everything and says, sure, I guess this is okay. Never a good idea. Never. Never, ever, ever. Can I say that one more time? Never. Why? For the same reasons with our prenuptial agreements, that the courts want to make sure there's no overreaching, there's no fraud. It's the same reason you want to have a lawyer represent both spouses in a dissolution. Now, can one lawyer represent both spouses? No. No, they can't. And the reason why they can't is, this goes back to agency, if you remember back to our business class, that an agent can only serve one master. So if I'm a lawyer and someone comes in my office and says, I want to get a dissolution from my spouse, I can only represent that person that came in the office. I don't represent the other spouse. And so when I'm putting together the paperwork and when I'm advising the person who came in my office, who is my client, the other person's not my client, I have an obligation to represent that individual to the fullest extent of my ability under the law. So if that person says, oh, I don't care if they keep the four-wheeler, I can tell my client, well, under the law, you would be entitled to keep that four-wheeler, so I'm not so sure that you would give up that four-wheeler. Why? And so you're getting counseling in how this process is going to go forward. The spouse who's not represented doesn't get the benefit of any of that. And so what the courts say is, look, there might be some overreach. Now, believe it or not, I have had one case where a dissolution was nullified. And the reason it was nullified is because the other spouse didn't have an attorney, and I represented the other spouse. I actually filed for the nullification of the dissolution because the one that was represented by counsel didn't disclose everything. Was hiding money, was hiding vehicles, was hiding income. And so at the time the contract, the separation agreement was put together, there was fraud and there was overreach. Right? Because I have the lawyer, have the ability to manipulate the situation, and you don't have the lawyer, and so I can get one over on you. And just like in any contract where there's no meeting of the minds, where there is fraud or duress or an overreach by one party, the court's going to say, nope, I can't accept this contract. Or this contract's no good because it was entered into fraudulently. So, both parties should have a lawyer. And I know there are tons and tons and tons of dissolutions that go through without a hitch, where there's only one lawyer. Okay, that is the C- way of doing things. If you want to do things A+, both parties get a lawyer. If they don't get a lawyer, there has to be a document included in all of the documents that you present with your petition for dissolution that says, I had a chance to get a lawyer. I represent that the lawyer, I understand that the lawyer that is putting together all this information is not my lawyer. And I'm choosing not to get a lawyer. And I sign on the dotted line. Okay? That's called the, hey, I might be doing something stupid, but I know I'm doing something stupid rule. So, that document, if there's only one lawyer that's putting all of these documents together, guess what? That document has to be included. Okay? Another document that has to be included in this bevy of documents is a waiver of service of process. What does that mean? Well, when you have an adversarial proceeding like a divorce, one person files the complaint, and either the sheriff or certified mail, you're going to get a knock on the door, you're going to get certified mail. So the court knows that you know that this proceeding is actually happening. Well, if everybody's agreeing and your name is on the petition and on the separation agreement, you must know what's going on. So you can say, look, we waive service of process. We don't need it. Don't take the time. Don't spend the money. We all know what's going on here. Okay? And both parties sign off on that. Okay? If there are children involved in the marriage where this dissolution is going to take place, there are documents that need to be signed showing that there have been no issues with abuse or neglect by either parent, where the children live, what kind of child support is going to be paid. Okay? Those documents have to be included. And most importantly, there has to be a petition of dissolution. Okay? That petition is the first document that the clerk of courts is going to see. And what goes into that? Well, there are several statutory requirements. What do I mean by that? There are certain things that are required by law to go into this petition for dissolution. Okay? The first is there has to be some kind of statement that you're legally married. Believe it or not, you have to put that in there. Otherwise, the court doesn't have jurisdiction or the ability legally to even look at this case. So you have to tell the court, yep, we're here and you have jurisdiction over us because we were married on this date in this place. We're married. Okay? First thing that's got to go in to any petition for dissolution. The next thing is, where do you live? If you don't live for 90 days within the county where you are filing for your dissolution, the court doesn't have jurisdiction. So, that's got to go in there. You also have to be living separate and apart for a number of days. That has to be put into the petition. If you haven't been living separate and apart, the court might think, hey, you know what? This is a little funny. They might be trying to get one over on us. So there has to be some statement in your petition for dissolution that says you've been living separate and apart for so many days. Okay? And each state has their own statutory time limitation for how long you have to be living separate and apart. If you have any children that are born as issue of the marriage, what does that mean? While you were married. If you have any children born as issue of your marriage, their dates of birth and social security numbers need to be put in the petition of dissolution. Why is that? The court has to know up front that there are certain orders that it is going to have to make for child support and for visitation, parental rights and responsibilities. Okay? So, and the other thing is sometimes there's disagreement about whether a child is born as issue of the marriage. Sometimes people have dalliances that were during a marriage, and maybe the child doesn't belong to the father. And so it's important that that agreed point goes into the petition, because remember, you're agreeing on everything in this petition for dissolution. Okay? Then you need to say why you want to terminate the marriage. Okay. This takes a little bit of history. Prior to 1970s-ish, you would have to prove very limited reasons why your marriage needed to be terminated. That didn't come out right. The statutes, the state would say, look, you can terminate a marriage for adultery, you can terminate a marriage for abandonment, for physical and mental abuse. Everything else, forget about it. Those are the only reasons why you can get a divorce. This is the only reasons why you can terminate a marriage in general. Dissolution, divorce, didn't matter. If these things didn't happen, you were staying married. The laws changed over time, and we ended up with, in addition to the adultery, mental, physical abuse, abandonment, we ended up with a no-fault divorce. We ended up with irreconcilable differences as being a reason why the court could allow you to terminate your marriage. Now, what does that mean? Irreconcilable differences. It could mean, look, we just don't agree on anything on one end of the spectrum, to he won't pick up his dirty socks, I'm done. It could be anything in between. It's what you decide it is. Irreconcilable differences. 99.9% of divorces that are granted today are grounded on the reason of irreconcilable differences, and 100% of the dissolutions. Okay? So you have to put the reason that you want the court to terminate your marriage. That reason has to come from statute. And so you pick one of those or all of them. And when we get to divorce, we're going to pick all of them. But for a dissolution, irreconcilable differences. So that has to be in the petition for dissolution. You also need to put in the petition, we agree on how to divide up everything, look at the separation agreement, and we wish for our marriage to be terminated. That's basically a petition. Now again, I'm going to show you a link so that you can look at some different petitions for dissolution, so that you can actually see what they look like. Okay? Once all of these documents are finished and signed and everybody agrees on it, there is a filing fee, because this is a civil action, right? No one's going to jail because of a dissolution. Not going to jail, it's a civil action. Everything else is criminal. Okay? So in a civil action, there's always a filing fee. Every county is different, but you better make sure who's going to pay that filing fee. And the lawyers are going to want to be paid before they even walk in the door, because the way dissolution works is you go in, you file everything, a hearing date is set, you go to that hearing, and you're done. It's not like this is a long-term thing. So most lawyers will charge a flat fee. What do I mean by that? I'll do a dissolution for $1,500. Not, I'm going to charge you $200 an hour or $100 an hour. I'm going to charge you a flat fee. And usually they will not file it until that flat fee is paid. Okay? These are the logistical parts of it. So let's say we have filed everything. We've got our hearing date. What happens at that hearing? Well, actually, they're very anticlimactic and kind of sad. Actually, I think dissolution hearings are much sadder than divorce hearings, because at least in a divorce, you've got some spunk left in you. You're fighting about something. With a dissolution, everybody's just kind of resigned. It's kind of sad. So what happens? The judge will call the parties in. You will stand, and the judge will ask each party a few questions. First of all, are you legally married? Second of all, for the wife, are you pregnant? Because if you are pregnant, the hearing can't go forward. Why do you think that is? Well, we have to determine who the father of the baby is. That baby will be born as issue of the marriage, and then will have to be encapsulated in some kind of addition to the separation agreement. Okay? So if the woman is pregnant, and I'm not woke enough to believe men are pregnant, so if the woman is pregnant, then there's going to be a continuance. That we're going to have to wait until after the baby's born. Okay? So they're going to ask if you're living separate or apart. They're going to say, did you read everything in the separation agreement? Yes. Do you have irreconcilable differences? Yes. Both parties have to say that. Is there anything you want to add to the separation agreement? You understand everything in the separation agreement. Now understand that the judge's job is to fairly and equitably divide up your assets and liabilities. Equitable does not mean equal. Doesn't mean 50% for you, 50% for you. It means equitable. It means, given the circumstances, fair. What's fair? And so the court's going to say, do you think it's fair that she gets the new car and you get the old car? Or do you think it's fair that he's keeping this and you're keeping that? There might be some pointed questions about maybe a few things that are in the separation agreement. And typically everybody says, yeah, that's fine with me. And once that happens, then the court will say, okay, I grant your dissolution. And we'll sign off on a judgment entry, because a court doesn't speak through the mouth of a judge, the court speaks through its entries. So the court will sign an entry that says your marriage is terminated as of this date, adopts the separation agreement as part of the record, which means you have to follow it, and then it gets filed with the clerk's office and the marriage is terminated. It literally takes 5 minutes. Clients are just absolutely flabbergasted that they walk in and within 5 minutes they're done. And typically what judges will do is they will schedule a whole morning of just dissolutions. And believe it or not, it is like a cattle call. They'll do 5 dissolution hearings an hour. And people come out kind of shell-shocked, like, wow, that was all there was to it? Yeah, that was all there was to it. If you agree on everything, the court, the judge in the black robe that you never met before, says, look, I don't know your stuff, you know your stuff. I'm not living your life, you live in your life. You decided this is what you wanted to do? Good enough for me. Okay? And that's how it works. Okay? So, dissolution is the least combative, most conciliatory way to terminate a marriage. Still kind of not so nice, but at least you are in control of how your life is divided up and how things are going to go. All right. Okay, I'm going to stop there for right now. I'm probably going to do another video just this week on mediation between parties before a divorce is settled, just as part of how family court works. And so that'll be 2 lectures this week. Make sure that you watch the second one. I'm going to provide a link for a petition for dissolution and a separation agreement, just so you can get an idea of how that works. Those should be in discussion. If I can't get them to work in discussion, I'm going to put them in the module and then you can talk about them in the discussion. Okay? And if you have any questions, please feel free to give me a call or email me. Thank you.